Hello, everyone. My name is Tim Sarsfield. I'm a partner in the Thompson Coburn Labor and Employment Group. And with me today is Stephanie Cohan. She's an associate in the Labor and Employment Group. And we're both working in our St. Louis office. And today, Steph and I are going to be talking to you about OSHA. We're going to be talking about increased penalties, increased enforcement, and some areas of emphasis, at least as we see it, in terms of what OSHA is interested in. Before we start our presentation, Stephanie has to go over some ground rules or some housekeeping matters.
Yes, thanks, Tim. Hello, everyone, and thank you for attending today's webinar. OSHA, increased penalties, increased enforcement, areas of emphasis. This webinar is part of Being Resourceful, Thompson Coburn's HR Law webinar series presented by the firm's labor and employment practice. Visit thompsoncoburn.com for more information on next month's program and to sign up for future webinar invitations and alerts. Before we begin, we wanted to cover a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We will try to answer these during the webcast, but if a fuller answer is needed or we run out of time, it will be answered later via email. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical issues located in the help widget at the bottom of your screen. This webinar is CLE accredited in California, Illinois, and Texas for 1 hour of general CLE credit, and in Missouri for 1.2 hours of general CLE credit. Additionally, this webinar is CLE accredited in New York for 1 hour of experienced and transition credit. The webinar is also approved for 1 hour of SHRM and HRCI credit. We award credit based on attendance for the entire 60 minutes. As required, we will display secret words in multiple choice polls during the webinar. You will be required to select today's secret word from a multiple choice list. Please respond to the polls to demonstrate your continued engagement and to earn your full credit. We value your opinions and appreciate your participation in the course.
All right, thank you, Steph. I'm going to start off talking about what OSHA is. OSHA is a federal agency that enforces a federal law that regulates health and safety in the workplace for most private employers. OSHA is somewhat unique in that it doesn't preempt the field the way the National Labor Relations Act or ERISA does. And on the other hand, it's not necessarily like Title VII or wage and hour, where it sort of sets the floor that then states can build on. Instead, states can actually develop their own plan, and they present it to OSHA and they say, hey, we want to opt out essentially from federal OSHA. We want to have our own plan and we want to run things ourselves. And if they get approval from OSHA, then federal law is in essence displaced. Now, state plans are supposed to be as effective as federal law. So generally they follow federal rules and regulations, but states can go further. Although, as we're going to discuss during the course of this presentation, sometimes OSHA gets frustrated with state plans because they don't think they are going far enough. One reason why I'm emphasizing this about state and federal plans is I have run into situations with clients where even clients who do a fair amount with OSHA, they'll have plans, say, in Missouri or in Arkansas, where federal law holds sway, and they kind of get used to doing things the federal way. And then they get plants in Virginia or they get plants in California, and they just assume that everything is going to be identical, but it's not always, because those states can have different requirements. Virginia and California being two examples of state plans. If you're in the mining business, which can include operating quarries, you're actually subject to a whole different regime. That would be MSHA, the Mining Safety and Health Administration. We're not really going to talk about that today. There's a couple of other private employers that are subject to regulation by different federal agencies, but for the vast majority of private employers, you're either going to be regulated by OSHA or you're going to be regulated by a state plan. One of the differences between state and federal plans is that traditionally state plan fines have not been as large as federal fines. And that has been somewhat of a source of tension, and I'll talk more about that in a minute here. But for example, in 2021, the average federal fine for a citation was about $3,100, whereas states range from a low of about $620 to a high of $9,580. No real surprise that at the high end it would be the state of California. But I know that the federal government has sent some letters to state plans saying, not so much about the average fine, but your penalty structure, it's not acceptable to us. As the slide says, if you're in Missouri or Illinois, you're subject to the federal OSHA. In the case of Illinois, it actually has its own plan and its own agency that regulates safety and health for state and local employees. Altogether, there's about 22 states and territories that have approved state plans, and those cover both private and public sector workers. As you can see from the slide, Iowa, Indiana, Tennessee, Minnesota, I probably could have put Kentucky up there, all have state plans. Arkansas, the Dakotas, Kansas, Nebraska, Oklahoma, they are subject to the federal law. If you want to figure out whether a particular establishment or location is in a federal state or in a state plan, you can go to OSHA.gov and you can find that on their website. And one thing that I will say is I deal a lot with federal agencies, and I'm actually pretty impressed with OSHA's website. It has a lot of good, useful information, and I think both Steph and I are going to be citing to it. You know, one final thought on this, you can't just go by, oh, it's a red state or it's a blue state, so this is what it's going to do. There's some very blue states that have opted out, and there's some very red states that have stayed in, and vice versa. So how does the process actually work? Well, an investigator either from the state or from OSHA shows up at your workplace. Now, how or why might they show up? Well, say, unfortunately, you had a death. You are obligated to report that to OSHA or to the state counterpart. Or if you have a work-related hospitalization, amputation, or loss of an eye, that will trigger an investigation. This is important to know that if you're sitting there thinking, and I've had this question asked of me a couple of times now, well, we generally are exempt from keeping the OSHA logs, recording injuries and stuff. Do we have to report if somebody dies or if somebody gets amputated? And the answer is yes, you do. You got 8 hours to report a death, 24 hours to report on the others. If you have done OSHA in the past but really haven't done it here recently, I was just asked this question the other day. What's the rule? How many people have to be hospitalized in order to trigger that reporting obligation? It's only one. Used to be more. Used to be 3, but they dropped that down to 1 a long time ago. One other thing about the hospitalization, it needs to be inpatient. So before you pick up the phone, make sure you know whether the guy was actually admitted to the hospital or not. Another way that OSHA can show up is a complaint. An employee or a former employee complains about you. Now, what is interesting, I think, on complaints is they don't always show up at your doorstep. Sometimes they do what I call a desk audit. They send you a letter that says, hey, we've gotten this complaint that there's something amiss with how you're handling forklifts or something amiss with how you're dealing with the heat. Then they will ask you a series of questions and they will look for documents. One thing clients always want to do is either have me pick up the phone and call the area, or they want to pick up the phone and call the area and go, who complained? Tell us who complained. You don't want to do that. Employees do have a right to go to OSHA, and they do have a right to complain to OSHA, and you can't retaliate against them. So it doesn't really do you any good to find out what their name is. On a personal level, I think a lot of times when you get these desk audits, OSHA already thinks there's something a little hinky about the complaint, and they don't necessarily want to send an investigator out to your plant. So they don't need you to beat up on somebody. Another way they can show up is referrals. You know, you're dealing with another agency and an investigator comes to your place and sees something that they think is amiss, and so they call a colleague at OSHA or at the state counterpart. OSHA doesn't do a lot of randoms, but they do have programs where they concentrate on high hazard industries or sites with high rates of injuries and illness. OSHA has 6 months to issue a citation. There's 3 components to the citation. There's the penalty, that's the monetary fine. There's an abatement date. If they told you did something wrong, they give you X period of time to correct it. And then there's the classification. You can be classified as either a repeat, a willful, a serious, an other than serious, or de minimis. And the importance of a classification, as we will see, is that can tie into the starting point for what the penalty might be. Something else that I've always been told is, different insurance carriers, workers' comp and such, they don't like to see repeats and willfuls or even seriouses. They don't put as much emphasis on an other than serious. So if you get a citation, what are your options? Well, you have 15 working days to either comply with the citation, request an informal conference with the area director, or file a notice of contest. The notice of contest isn't really that complicated. It's only a sentence or 2. Next. I always recommend that you do the informal conference, even if you're just thinking, hey, we're guilty, we're just going to go along with this, or by God, we're going to fight this all the way to the Supreme Court. It doesn't hurt to ask for an informal conference with the area director, especially if you're just thinking about surrendering. It's not a very long process. Usually the informal conference is slotted for an hour. These days, you can do it by Teams or Zoom or just over the phone. And what my experience has been is you can usually go in and get at least part of the penalty knocked off. You can get extensions on your abatement. The area directors or their designees, if you have a good argument about a particular issue, they will vacate it. Or you can sometimes even get them to reclassify. Personally, one thing that I have found to be very helpful is bring a high-ranking person, show OSHA or show that state counterpart that you really do take safety seriously. It's important enough that you brought in the vice president of whatever or the president of the company. That person doesn't have to say a lot, just their mere presence on the phone or in person shows that you really do care. One thing is, if you do request informal conference, that doesn't toll the time period for filing your notice of contest. You got to do that within 15 working days of your receipt of the citation. If you file the notice, you go into litigation. It's an administrative process, no juries. these are ALJs, this is what they do for a living. They hear these kinds of cases. There is an appeals process. There's some discovery. How much discovery you're entitled to as a matter of right varies a little bit between state and federals. One thing you always want to get a hold of is the investigative file. There's a lot of information in there, and frankly, sometimes the area doesn't do a good job of explaining why they cited you for something, and then you get the investigative file and you're like, oh, now I understand. Kind of put this slide out of order. You know, when that investigator shows up, at least sometimes you could tell them, go get a warrant. I recommend against doing that. That just hardens everything. I mean, they will get it. And now all you've got is one really angry investigator. But, you know, some things that you want to know is who's going to be your contact person, who's going to deal with the OSHA person. You know, the OSHA person will show you their credentials, but they will sit down with you and they will explain why they're there. You know, what is it that they're interested in? And that's important because if they're interested in Department A, figure out the best and shortest route to get them to Department A. Don't take them on a big tour of the entire plant, because even if they were there because they were worried about machine guarding in Department A, if they see some problem in Department B, they will write you up for that. But don't be afraid to spruce up. Okay, there was an accident and you reported it to OSHA. They don't always show up the same day or within the hour. Sometimes it can take them a couple of days to send an investigator. So don't be afraid to walk around your plant and put things in order. Make sure your notices are put up. If that exit light has been out over the emergency door, get it fixed. You know, next. Some common defenses are the statute of limitations. There's a general duty, that's sort of a catch-all, as I'll discuss in a minute. They're not supposed to use the general duty when there's an actual standard in place. Sometimes you can fight about whether the standard is applicable to you or not. Obviously, a good one is we did comply with the standard. We don't understand why you don't believe that we did. One thing that employers always want to do, especially in a case where somebody has actually been injured, is argue, well, it was employee misconduct. What were we supposed to do? My experience is OSHA and state plans don't necessarily like that defense very much. It's your burden to prove it. So you're going to need to prove up that you actually had a rule, that you trained the employee on the rule, and then more importantly, that you had enforced the rule previously. You know, you would enforce it before somebody was killed or injured. Penalties in 2023, the current max under OSHA for a repeat offense is $156,259. And what OSHA will do is they will look back over a prior 5 years to see whether you've had the same or similar offenses. And if you do, they will hit you for a repeat offense or citation. In terms of what they look at, OSHA tends not to look at citations that were issued to other establishments by state plans, and usually the state plans don't look to the feds. It's been a mixed bag in my experience, whether OSHA, for example, in Illinois, pays that close of attention to what OSHA up in Maine did, but certainly if it's the same establishment or in their area, they will tag you with a repeat. If you want to find out what the history of an establishment is, again, you can go to OSHA.gov. You can go under their Help and Resources tab, and you can get to the establishment page. And if you're an outside counsel that's been hired to represent a company, or if you're new to the company and there's not a lot of institutional memory, you can do searches and figure out what is your company's record. Willful is the same in terms of the max for a repeat offense. Willful, the standard there is basically if they get the impression that yeah, we didn't want the guy to get killed, but hey, stuff happens. You will get hit with a willful. The penalty for serious and other serious is about 15,622.5. The penalties go up every year in January. They're adjusted for inflation. For years and years and years, the penalties were set. I started doing OSHA work in 1992 or 3. A serious was 7,500, a willful was 75,000. Starting in 2016, they started to adjust things for inflation. The penalty is based on when the citation is issued, not when the violation occurred. The area directors do have some discretion to make adjustments based on the size of the company, how they perceive your good faith, your prior record, and what they call the gravity of the situation. They do realize that not all violations are the same, so they will classify something. What's the likelihood that it would have happened? What's the likelihood that if something bad happened, somebody would be seriously injured or killed? If it's high, you're not going to get much of an adjustment. If it's low, usually you can get an adjustment, at least on serious and other than serious penalties. Next. The only thing that you really get for repeat is your size. Size and history will help you out on a willful. You don't get a size reduction for serious if you have over 251 employees. An issue that I have dealt with quite often with OSHA is where they try to lump related companies together to get you over that 250 mark. As I mentioned, one problem that OSHA has right now with various states is they feel like states are dragging their feet on increasing penalties. It got so bad with Arizona that OSHA threatened to take away their plan status. And South Carolina right now is actually gone to court to argue, no, we don't have to increase our penalties, but they've issued warnings to a number of states. You've got to increase the size of your base penalties. Now, Oregon, those guys that were down there at 620 apparently got the message. They've recently raised their maximum fine to $250,000 in death cases. And for a serious violation, their fines now can range from $20,000 to $50,000. One thing that I do think is important to note is starting at the end of 23, OSHA said that they're going to start being more aggressive in issuing what they call instant by instance citations. And what that means is, in the past, if OSHA came in and you had 10 pieces of identical equipment and they didn't like the guarding, they'd issue one citation. Now they're talking about issuing 10 citations. Or in the past, if you've had 4 guys down in a trench and you were violating a standard, they would issue 1 citation. Now they might issue 4 citations. So it's going to be interesting to see just how far they take that, and presumably state plans will start following suit. Sources of law, there's this general duty, which I talked about, and there's standards. Think of those as regulations. This is what you must do to have appropriate machine guarding, or this is what you must do to have appropriate fall protection, etc. Next. One thing that you can go to OSHA if you're trying to figure out, well, what should I focus my attention on, is you can go to OSHA and you can go to the enforcement tab, and you can click on what they call their national emphasis programs. And I listed a few of them that are really, really important to them. And they will also then cite you to resources or to associations that you can turn to try to get some guidance on how to, meet your requirements for trenching and excavation and the like. I didn't put this on a slide. Another thing that you can do is you can see what the local emphasis programs are. One of the reasons why Stephanie's going to be talking about heat here is because that's one of their national emphasis programs. All right. One of the reasons we're going to talk about forklifts is a lot of the areas or a lot of the regions across the country have put that up pretty high on their list. My understanding is, boy, if a forklift is involved, if the complaint involves a forklift or the incident involved a forklift, you will get an investigator and they will carefully scrutinize your training and your record keeping when it comes to forklifts. Next. You know, one question that sometimes I get asked is, hey, I just got hired. I don't have a lot of experience. I'm not sure we're doing things right. What should I be focusing on? So what I've listed on the next two slides are 2022's most common citations, okay? This list really doesn't change from year to year. So if you're just befuddled where to start, just go down here. Make sure you got a fall protection program or a lockout tagout program, etc. As I said, OSHA has got a good website, and I gave you two links there. The first one will take you to this most common citations, but in addition, it will have links that will help you not only find the regulation, but links that will help you comply with your forklift requirements or your machine guarding requirements. Another thing that I always tell associates is go to that one thing about subscriptions and sign up for some of the newsletters. OSHA sends out a tip of the day, and I get it every morning. And this tip of the day could either remind you, oh yeah, we need to do training on this, or we need to do training on that. But it also kind of tell you what's OSHA thinking is important. And lately, heat has been the focus of their tip of the day. Before Stephanie talks, we have to do our first secret word. Today's first secret word is federal. Please select the correct word from below. And again, the secret word is federal. All right?
Right. Hopefully you had enough time to select that secret word. And as Tim just mentioned, I am going to start talking to you about heat standard. And notably, there is no federal standard for heat. This is something else that will fall under the general duty clause because of the fact that there is no standard for heat. And citations that are issued would be issued under the general duty clause. However, the discussion about a federal heat standard is not something that's new. This discussion has been going on for a long time. Notably, in 2016, the National Institute for Occupational Safety and Health published criteria for a recommended standard. And that discussion since then has continued, and how the standard would come about and then how it would be applied is something that's continuing today. As Tim also mentioned, the OSHA website is a great resource for information on this ongoing discussion, and you can access that information on OSHA.gov. So in April of 2022, a national emphasis program was developed, and this describes policies and procedures for the implementation of a national emphasis program. Notably, OSHA has indicated that heat-related inspections have accounted for 0.5% of all federal inspections during the last 5 years. And, because of that, there really is an emphasis and a push to get this standard together. And the goal of the current national emphasis program is to reduce or eliminate worker exposures to heat-related hazards. But, as I mentioned, this program really is just the policies and procedures for implementing another program. There are regional emphasis programs, and as Tim mentioned, there are certain areas of the country that are already focused in on these topics. And in Arkansas, Louisiana, Oklahoma, and Texas, there is an emphasis program that indicates that there's a strong emphasis on outdoor job activities that occur in this region, specifically looking at days where the heat index is above 80 degrees Fahrenheit. And included in this regional emphasis program, other hazards that occur, due to this temperature will also be addressed. But as I mentioned, because there's no standard, citations will be issued under the general duty clause. So OSHA has some really great tips for how to address heat and look at these issues, even though there is no standard currently. First, OSHA suggests that a person is designated to oversee the heat stress program at a work site. Also, it's important to identify what hazards might exist. So that could be both outdoor and indoor hazards that would relate to heat and increase any kind of risk that might be there. OSHA also suggests that looking at water, rest, and shade, so making sure that employees have access to water, that they're able to rest, and that there's areas of shade is also something that's important. Acclimatization, so allowing employees to have time to get acclimated to heat and ensuring that time, is given, that enough time is given so that employees really can make sure that they're comfortable in working conditions that may be high heat. Also, potentially looking at modified work schedules to see if work could be done at times where where the heat may not be so high. Also looking at training. We're going to talk about training in other contexts today, and training is a big component of this, and making sure that employees understand issues related to heat and what those hazards might be. Also, knowing how to monitor for heat illness symptoms and making sure that you're in tune with your workforce, and if people are demonstrating heat illness symptoms, that they're addressing those, and also developing an emergency response plan so that if there are issues of heat, that response plan helps to prevent any further issues from happening. And again, the OSHA website is a great resource for this. So while there is no federal heat standard, there does seem to be a number of states that have implemented state heat standards. Right now, there are at least 5 states that have these state heat standards. And some states address both outdoor heat and indoor heat, while other states address only outdoor heat. If you are located in one of these 5 states, it is important that you make sure you take a look at those state heat standards to understand the requirements. Additionally, the heat that is sort of that target heat that these states are looking at for when a hazard may be at play or when the law may be implicated, that also changes across states. So understanding what those numbers are is also important too. There's also been a bit of a trend in states continuing to build these state heat standards. So while right now there are these 5 states with these heat standards, especially if there continues to be no federal heat standard, I think that we anticipate seeing more states decide to implement heat standards and put these in their laws.
Yeah, a couple of things here. First, I think this is a classic example of what I was talking about before, that you do need to know when you have locations in different states, who's actually running the show. It would be very simple for somebody to say, well, in Missouri, my plants are governed by federal law and there's no heat standard. But if you're up in Minnesota, there is. Or if you have a plant out in Oregon or in any of these other states. So that's why it is important to get your arms around who's running the show for all of my different locations when you're scattered around the country. One of our guests, I guess, sent a note that said OSHA Quick Takes is a very good source of information related to the agency. That can be found at osha.gov/quick takes. And I am familiar with that. I sign up for it. And it's funny how often, if I'm working on an OSHA related matter, something will pop up on a quick take that I can then use to track down something.
And as Tim also previously mentioned, forklifts is another area that seems to be an area of particular focus for OSHA. So I want to go through and talk about where things are, and then discuss some of training for forklifts as well. There are specific requirements listed by OSHA for powered industrial trucks, which are also forklifts. And the hazards commonly associated with forklifts vary depending on the vehicle type and the workplace where the truck is issued. Each type of truck presents different operating hazards. So depending on the type of truck, the operator may have different considerations, and there just are different types of skills that may be associated with operating different types of trucks. Additionally, workplace conditions also present different hazards. Establishment that has customers or people there are going to face greater challenges than work sites that don't have to think about pedestrians or other folks walking around. I want to note too that it's a violation of federal law for anyone under 18 years of age to operate a forklift, or for anyone over 18 years of age who is not properly trained and certified to do so. So requirements regarding forklifts are that pre-operation, that there's an inspection, and that they ensure that they maintain the forklift before use. Additionally, that the forklift is in good operating practices to avoid accidents. Additionally, there's a requirement to identify hazards and recommend practices for each step in the load handling process. So, as I noted, training is a big part of forklifts, and understanding that at your job site. And employers are required to develop and implement a training program for forklifts. Trained operators must know how to do the job properly and do it safely. The training program uses general principles of safe truck operation. So again, as we talked about before, this is looking both at the type of vehicle and then also looking at hazards of the workplace. So training may be a little different from place to place depending on what type of forklift is being operated, and then also what specific hazards might exist in the workplace.
I just want to make a comment there. It's been my experience that two things seem to catch OSHA's eye or their interest. They are quite adamant that your people need to be trained on the forklifts that you're using in that warehouse. I can't stress that enough. I've had some clients get into trouble because, and I'm going to get a little ahead here, they had, an agency send them a guy who was like, yeah, I drove a forklift for 20 years for A and B. And then they just put him out there. The guy might not be lying. He may have driven forklifts for A and B for 20 years, and he might be very competent. But if you don't have the records to show that he's competent and trained on your equipment, that can lead to trouble. And just generally speaking, one thing that I would encourage everyone to do, whether it's forklift training or any other kind of training, I see a real emphasis from investigators these days wanting to make sure that you are documenting stuff and keeping the records that you're supposed to be keeping. Sorry.
No, thanks, Tim. Just in looking at training, so both formal and practical training needs to be provided. And as Tim just mentioned about documentation and why it's important, employers also have to evaluate each operator at least once every 3 years. So if you don't have that documentation that an operator was trained and evaluated, then there's no way to show that they have done this every 3 years. So again, that just speaks to how important that documentation is, both for your own records and also to provide to OSHA. And refresher training is another piece that's important. Refresher training is needed whenever an operator demonstrates a deficiency in the safe operation of a truck. That can vary in terms of what that training looks like as well. As I mentioned previously, employers must certify that each operator has been trained and evaluated in accordance with the OSHA standard. So the certification has to include certain things, and that's the operator name, the training date, the evaluation date, and the name of the person or persons performing the training or evaluation. So the regulations outline a number of truck-related topics that training has to include. I'm not going to go through each one of them today, but I did want to provide you with a list of what those truck-related topics are, so that you can take a look and be aware of what's needed in terms of that training. Additionally, workplace-related training topics are also required, those two are listed here. They include surface conditions and load manipulation, whether there are narrow aisles, those kinds of things that we talked about that may also lead to an analysis and assessment of the hazards that exist at your specific work location. There are only certain times that a trainee can operate a forklift, and that's under the direct supervision of persons who have knowledge, training, and experience to train operators and evaluate their competence, and where such operation will not endanger the trainee or other employees that are around. So if you don't yet have confidence in that trainee who's learning how to use that forklift, maybe hold off on letting them operate it, and and only doing so when you know that the operation of that forklift is not going to endanger either the trainee or any other employee. So I did just briefly talk about refresher training, and I'll give you just a little bit more information on that. But generally speaking, refresher training has to occur when the operator has been observed to operate the vehicle in an unsafe manner, or there's been an accident, or the operator's received an evaluation that shows that they're not operating the truck safely, or if there's a new truck that the operator is assigned to drive, or if a condition in the workplace changes the manner that could affect the safe operation of the truck. So again, looking at those workplace hazards. All right, so shifting gears just a little bit, we just wanted to highlight some considerations that arise for temporary employees. This is an issue that has come up a number of times for us, and in looking at who is in control of the temporary employee, and who needs to do training, and who is responsible for temporary workers' safety and health. So I think importantly here that temporary staffing agency and the host employers share control over the worker. and therefore they do have a joint responsibility for temporary workers' safety and health. There's a concern that employers, may be using this as a way to get out of some of their obligations. And so it's something that's important to really take note of if you're an employer that has temporary employees, to know that there's a responsibility for both the staffing agency and the employer to ensure that a temporary worker is working in a safe condition.
Okay, now we're to the second secret word. Today's second secret word is penalty. Please select the correct word from the list below. And again, the secret word is penalty.
I'll give you just a couple more seconds to pick that secret word.
Just to real quickly go back to this temporary employee, one thing that I have seen quite a bit of here is that gets overlooked is if you have temporary employees running around your establishment that you essentially supervise, from OSHA's perspective, it's your responsibility to record it on your log if one of them gets hurt or injured. It's not good enough that the temp agency is recording it on their particular log. Just as a general matter, if you are working in an environment where there are employees from a lot of different employers, somebody missed the I'm not sure what you can do if you missed the first secret word. We will try to look into that. Okay. It's okay. You need to be cognizant of OSHA can find you liable if you create a hazard that exposes somebody else's employees to the risk of injury or death. So don't just think, well, that's on the other guy. You have an obligation to protect employees that are at your facilities no matter what. But we would talk a little bit about some stuff that might be coming down the pike. I just did this slide yesterday because once again, something popped up on my screen that apparently OSHA is concerned about employees that are being exposed to poor air quality due to wildfires. And they think you need to have a plan in order to protect those employees against that sort of exposure. And again, going back to different states, Oregon actually has a standard on this, as does California, and Washington adopted an emergency standard back in 2022. Another thing that I'm seeing more and more stuff in the different services that I get is OSHA is concerned very much about workplace violence. They're concerned about workplace violence in general, and they're specifically concerned about workplace violence in hospitals. And I was a little bit surprised by this. In 2019, about 5,333 people were killed in the workplace, and roughly 14% of those deaths were the direct result of someone trying to intentionally injure them. I was surprised that the number or that percentage was that high. If you're in the healthcare industry, they are seriously considering adopting a standard at least specific to healthcare violence. So if you're involved in any of these particular areas, there's probably a standard coming down the road, and you ought to also be aware that a number of states have, either in the OSHA context or outside of the OSHA context, have specific rules and regulations in place for healthcare type of facilities, because the situation involving violence has gotten so bad. I was telling my wife the other day, our son was in the Army for 6 years, and we spent a lot of time worrying about him, or at least my wife spent a lot of time worrying about him. And it turns out we should have been more worried about our daughter, who's a nurse practitioner. Next slide. Again, why are they so concerned? Violence is about 5 times more prevalent in a healthcare setting than in any other setting. This rule is going to focus in particular on what they call type 2 violence, protecting your employees against violence committed by customers, clients, or patients. And again, if you're in the healthcare industry and you want to get ahead of the curve, that's a good link that can help you sort of decide things that you might consider doing in order to protect your workforce.
Mental health is another area that we see OSHA really focusing in on, that is likely going to be, of a great importance. According to OSHA, more than 80% of workers have reported experiencing workplace stress, and more than 50% believe their stress related to work impacts their life at home. This is really a staggering number, and it indicates that workplace stress is something that really affects pretty much most of us. And the support for this, kind of the mental health push by OSHA is generally supported, but OSHA does not have any regulations that address workplace stress, and it generally does not regulate mental health hazards. As of right now, the record keeping, it doesn't need to be reported in the same way that other types of workplace hazards do need to be reported. Because of that and the fact that there are no regulations right now, workplace stress is something that would be enforced under the general duty clause. Right now, there's also no procedures in place for inspection of workplace stress. As I mentioned, there's no standards in place either. But we anticipate that as this issue is developed, because of the widespread nature of it and the fact that it does seem to impact a lot of people in the workplace, as the issue is developed, we anticipate further action from OSHA. So some things that employers can do that they can, be aware and acknowledge that people can carry an emotional load that's unique to their own circumstances. So, that's an understanding that even though, I might not be facing one thing, somebody else may be having a circumstance that you might not even be aware of, and that may be causing emotional stress on them. Employers can also identify factors that are making it hard for workers to get their jobs done, and also determine if adjustments can be made. Obviously, I think, it should go without saying that employers can show empathy. Again, understanding that all people go through things at certain times, and just having that empathy makes it go, a little farther as well. And that employers can provide access to coping and resiliency resources. These can vary, and there's a lot of resources that are out there. And it may be something that as an employer, you consider providing your employees with access to these resources. Again, the OSHA website is a good place to go to for more information on this.
Hey, somebody had asked a question about, are we going to send the slides out? My understanding is there's a widget at the bottom of your screen where you can access and presumably print off the slides. And the smart person in the room is nodding her head. There was a comment that workplace stress, no, there is no standard in place right now, but actually if you get a doctor's note that says this person is off of work because of stress induced by work, that may end up being something you're going to have to record on your OSHA log. And then there was another question, and hopefully I'm understanding this correctly, is if you have a temporary employee and you're supervising them and they get injured, you as the host employer need to record that on your log. And then that sort of information, if you have an electronic reporting obligation, would be included in the materials that you're submitting to OSHA. So we've gone a little bit over our time. Thank you. Thank you for participating in our webinar. Please complete and submit the survey that will display at the conclusion of the webinar. And again, you can find the slides in a widget at the bottom of your screen. Thank you.